breaking development out of the Supreme Court this morning. The justices ruling on Donald Trump's immunity case. The Supreme Court ruling a former president has absolute immunity from prosecution for all official acts and no immunity for unofficial acts. But here's a twist here. The court did not decide what qualifies as an official act, and this is all connected to that trial against the former president on charges of plotting to subvert the 2020 election. We're joined now by David Levine from UC San Francisco College of Law. Thank you so much for joining us this morning again.
Absolutely.
The big decision finally handed down, 6-3, dividing along partisan lines here. No surprise there. But tell us what you thought about this ruling.
Well, it might have been a bit of a surprise because the lower courts were so strongly on the side of saying that there's no immunity in these cases. The fact that all 6 of the more conservative justices came together might have been a bit of a surprise here. Now, what the justices have done is, if we look backwards on the January 6th case, what the court has done is they've said that certain things we now know Mr. Trump cannot be prosecuted for. So the one that they mentioned in particular is using the Justice Department. So when Mr. Trump called one of the deputy attorney generals, Jeffrey Clark, to get him involved in the plot, allegedly, that's now completely off the table.
So they're saying that's official duties?
That is core constitutional. There's actually another level that they put in here to make it more complicated. But they specifically talk about that. So as a practical matter, the fact that Mr. Trump was trying to use a top official of the Justice Department to further the plot, say, to stop the count in Georgia, is now going to be off the table.
So, which is like the key part of the case against him. So this essentially means that this case would fall apart for him.
Well, that part.
Yeah, that part of the case, right.
And so that what the court has said is that the lower court judge, Judge Shutkin, now has to parse out what can remain and what can't remain.
So what's official and not official?
Official and not official is part of it, but there are other nuances to it. But basically, that's the split. But for example, one that Chief Justice Robert talks about is that when Mr. Trump was pressuring Vice President Pence, that takes a little bit more consideration. Why? Because Vice President Pence really wears 2 hats. He's part of the executive branch when he's advising the president, but he also presides over the Senate as an officer of the legislature. And so that it's going to require a little bit of parsing to decide what was Mr. Trump doing when he was talking to, pressuring Mr. Pence, and then what would constitute unofficial conduct. So they talk about, for example, the speech Mr. Trump gave on January 6th before sending everybody up to the Capitol. That also is going to require some parsing in terms of what will remain. Now, one of the most important... Go ahead.
Jack Smith is saying that speech was part of, you know, leading to the January 6th insurrection.
It's
and
all,
that was
absolutely
all part of it. But one of the justices said that could be his free speech to say something like that, I believe.
Well, free speech might be one thing, but inciting a riot is another matter. So he always had a First Amendment protection there, for sure. But the question is, when he was there on the Capitol lips, exhorting people to go to the Capitol to protest, or else there won't be a country, all of that, was that an official act of the President of the United States, or was that an unofficial act of a candidate?
A campaign,
right. And that's going to require parsing. Now, the other thing about this decision, and this is where Justices Sotomayor and Jackson were so emphatic, is looking forward. What this opinion does is that if you want to be corrupt, if you want to take advantage of the levers of power to go after your enemies, you hear Mr. Trump talking about retribution will be mine, all of that. What this opinion does is it shows him and future presidents exactly how to do it and to avoid criminal prosecution.
Wow, that is very interesting, and it's a big change, to be sure.
This is enormous, enormous.
All right, and of course, that goes back to the lower court, and the trial that's surrounding all this, that's definitely not going to happen before November. And if Trump becomes president and becomes President Trump, I think the idea is he can squash that case
He could
altogether.
absolutely squash it. Now, what probably will happen before the election is that this hearing will probably take place, which will parse things out, where the trial judge will be able to hear from witnesses and will be able to say, okay, under this new ruling, A, B, C, and D can still go forward in a trial, but E and F can't go forward in a trial. And so that we will probably learn quite a bit about the evidence that the prosecutors have, but it'll be in the guise of a hearing in front of the judge, not in front of a jury.
Gotcha.
So we'll get some information.
We'll see what happens there.
But in terms of the big picture, if you are on Mr. Trump's team for the next presidential election and for the next administration, you have to be happy, because this is the roadmap to just take over the government and do whatever you want as president. Now, his underlings still have to be careful. They still can be prosecuted. But if you're the president, it's clear skies ahead.
Let's get to another ruling that not many people talked about. It's not even widely written about, and that's called Corner Post, Inc. versus Board of Governors. And this involves government regulations, just like the Chevron case we talked about that happened on Friday. Tell us about Corner Post versus Board of Governors and what it means.
Right. Now, you're right that this will get less attention than the presidential immunity case, but in terms of the functioning of government, this is also very important.
This is huge,
Very important, because last week what the Supreme Court did is that they knocked out this 40-year-old precedent which required judges to give deference to expert administrative agencies. Now, what this new case from this morning does is that it gives a big time frame for when those administrative agency decisions can be challenged. So what people who want to knock out regulations can do. Let's talk about mifepristone. We talked about that before. The FDA made decisions about mifepristone years and years ago. What this decision does is it allows somebody to come forward now to say, you know what, let's look back 20 years.
And challenge the regulation.
And challenge the regulation. So it further limits the power of administrative agencies to do the work that we've understood since at least the New Deal.
So when these federal regulators issue a ruling, is it not challengeable for a certain amount of time? How does that work? Do we know?
You could always make a challenge. If something happened to you, you can make a challenge with respect to your own conduct. You could say, I didn't do it or whatever. But what this does is it opens up the door to further challenges of the regulations themselves. So the safety of mifepristone is a really good example. The FDA years and years ago decided that it was a very safe product. Now what this does is it allows you to come forward and say, now let's look back.
The bottom line is, if regulation is going to be, you can challenge regulations now more than you could before this ruling happened. And that means if I wanted to open a coal plant in downtown Oakland and spew coal into the air, I can challenge the EPA about doing that, about that law that forbids me from putting a certain amount of coal into the air.
Right. And with the opinion from last week, the trial judges are going to be able to say, I disagree with what the administrative agency did.
Not the scientists in the administrative agency that went, they did the research to make these rules.
So
a judge who's not an expert.
The lay judge, some random district court judge somewhere in the country, is going to be able to make that decision in the first instance, subject to appeal, but to be able to say, I disagree with the experts, whether we're talking about alcohol, tobacco, and firearms, with respect to bump stocks, whether we're talking about the safety of drugs, whether we're talking about air pollution. All of those things are now subject to this challenge. So do you put these two things together? The president gets enormous power, the judges get enormous power, the executive branch less power, and Congress less power.
So who has the power now? Corporations, and they have more power, the judges have more power. Is that what we're looking at here in the future, based on what we're seeing? Just, in just a basic term.
Right. Well, corporations will be given more opportunities to challenge official action, and judges will have more power to say, you know what, I agree with that corporation and I disagree with the administrative agency. That's where this will make a big change.
Let's go back to bump stocks you mentioned just a moment ago. There's an interesting article in Slate magazine questioning the opinion of Justice Clarence Thomas. They overturned the ban on bump stocks that President Trump at the time put into place, saying, there's no need for this. It's not an automatic machine gun, which the ATF designates them an automatic machine gun. But the bump stock attachment, Clarence Thomas did not think so. The information he used in his opinion, though, came from what Slate argues was a right-wing website. The information that the justices use in their opinion, is that unusual to see some of that information from maybe perhaps a source that is not a nationally recognized source?
What we have seen more and more is that the justices have relied on material that's coming in through what we call friends of the court briefs. And so that's material that hasn't been vetted through the administrative agency process.
Wow.
So
the amicus
brief, so that the Bumstock opinion is a really good example with some of the drug cases. We've had some of the same things. So again, it gives, as we're talking about free reign for judges to make these independent judgments, they also have some free reign in terms of saying where are they going to pull information.
Seems a little strange,
that's also
though.
part of it.
I was kind of surprised to read that information about what was used in these opinions.
That's right.
These are the laws of the land, and the information used in them, sometimes it may be questionable to some if it's not an official source.
Right, and it hasn't really been tested, say, through a trial or through an administrative agency process, so the judges can kind of pick and choose. That's part of the claim with respect to what many of these opinions have done, is that they cherry pick what they want to support their position, and it's not giving us a full picture. So it's a very different government.
Sounds pretty partisan.
Going forward.
Yeah, not necessarily.
It can be very partisan, but it certainly is. We're going to have a very different government going forward, especially if we get a new administration next year. We're going to have a wildly different government.
David Levine, thank you for stopping by and talking with us. It's been an interesting chat with you. I could talk with you more about this because it gets deep and into the weeds for sure.
Right.
Appreciate your time.
Another day, though.
Yeah, for sure. All right. Coming up on Mornings at 2.